Okay, so we read our democratic constitution, which was by Breyer. And as a brief summary of that, a few things he talked about. First is active versus modern liberty. He's a big believer in active liberty and the importance of that, and we'll define that later. But that's kind of like the power of the people to get involved in government. He also talks about how he believes the court should derive decisions and ideals from the Constitution as a whole and not specific provisions, and that there should be a lot of case-by-case basis, which leads to the consequential approach, which takes consequences into account when making decisions and tries to tailor each specific case to the decision that comes with it, which will lead to more cases in the future and a better democratic process.
Okay, so some information about Breyer. He was a former professor at Harvard, and he was appointed by Bill Clinton in 1994, which means that he's a liberal. Bill Clinton's a Democrat. This portion of our democratic constitution is actually just a part of his longer book about the subject, and even within the section that we read, they omitted some parts that they didn't think were important. As a liberal judge, he thought that conservative rulings messed with the actual meaning of the Constitution more often than the liberal rulings. And while judicial activism could be considered more liberal, Breyer thinks that in his case, the conservatives were practicing more judicial activism than restraint.
All right, this next section is about active and modern liberty. I'm going to go ahead and define active liberty. By the way, this is Kevin. Active liberty is also known as ancient liberty. It's kind of based off full democracy and the full participation of everybody involved in the democracy. And obviously Breyer is for this. He also mentions that there's an increased emphasis will give better constitutional law on decisions. He also says that in a sense, active liberty is true democracy, like I mentioned earlier, and it's mostly just based on full participation and everybody being fully involved at all times with democracy.
Like it was in ancient times.
Yeah, like we're about to talk about Socrates and his candid moments in the Greek life. Speaking of Greek life, we have Andrew Bramlett right here.
So with Socrates, there was obviously active liberty back in ancient Greece, but they weren't given full modern liberties like we are now. And Socrates was very politically active. He was always asking questions and talking. And this eventually led to his imprisonment and death. So Breyer, by saying that active liberty is not a sufficient condition for human liberty, he's just saying that not only do you need active, but you also need modern liberties, like we're about to discuss, protected in the Bill of Rights, to make sure that everyone has true human liberty.
Okay, this is McKenna, and I'm going to be talking about modern liberty, which is, Breyer gives two sides, two different kinds of liberties. He talks about activism and modern liberty. And so modern liberty is basically individuality. He says that it provides freedom from government restraint and focuses on individual rights. Commerce is the crucial force for the development of modern liberty because that's where people can exercise their individualism the most.
Their freedom of speech and assembly and
all the other freedoms.
all the lovely freedoms that we have in this country.
It's also important to keep in mind that modern liberty is really well established through our Bill of Rights today. And
True.
Yeah, and Breyer, he's very for active liberty rather than modern liberty, but he also argues that a mixture of the two should be used in the courts.
Okay, so some examples of active liberty, which is basically just pure democracy, which is everybody involved, everybody helps make decisions. So some examples include the freedom to vote and public policy making and civilian involvement in the government in general. And
Basically,
Okay,
any
you-
sort of active involvement in government is active liberty. It's kind of self-explanatory.
Yeah, pretty much.
Okay, so then for some examples for modern liberty, we just have the freedoms protected by the Bill of Rights, freedom of speech, freedom of religion. Any individual freedom of or right that we have would be considered a modern liberty, like what would keep Socrates alive today for talking. He wouldn't get killed for that.
Too bad.
And it even goes into more specific issues like gun rights. There's a Gun-Free School Zone Act that Breyer had issue with in a ruling in one of his court decisions. He was in the minority for that and had a problem with the way the court ruled. Anything that boosts individuality is going to be modern liberty. So these are definitely important, but Breyer would argue that these examples, while important, need to be taken into consideration with active liberty and not just completely override them just for the sake of having these liberties.
So now Kevin and I are going to talk to you about, I'm Thomas, by the way, are going to talk to you about the consequential approach that Breyer mentions. And the basis of this consequential approach is that in interpreting the Constitution, you shouldn't use specific provisions of it to make your decisions about how to interpret it. You should take the underlying meaning of the entire Constitution and try and understand its purpose to make your decisions.
It's also important to keep in mind that the consequential approach really applies to policy making as much as it does with interpreting things. Breyer was convinced that in order to make effective policy, we should also think about what the future could hold for that policy. So instead of solving problems in the now, he also believed strongly that we should solve problems now and also consider what will happen eventually involving the law in order to maintain its and the Constitution's effectiveness.
Breyer makes the distinction between literalist judges and consequential judges. Literal judges are more focused on history and tradition in their decision making, like what happened in the past. They're going to continue to follow those precedents and not really think about the future or what could happen in the future. While consequential judges think more about the underlying purpose of the Constitution, how they want to further those purposes through their decision making, and how those decisions will affect people in the future.
These rules also don't specifically apply to the Constitution. It also involves statutory laws, including laws and statutes, I guess, that were implemented after the original drafting of the Constitution. So by interpreting it separately from like previous precedents, it's also maintaining the fluidity of the document and maintaining its ability to apply to the future and apply to the current state as opposed to only applying to the past.